appeal in the matter of VHR.
You're going to tell me to move forward. Well, why don't you all move forward a row? Very good of you to respect the silk gown, but there aren't any here, so why don't you come further forward? Right. So, Miss Fairclough, you're for the appellant.
Yes, my lord.
And Miss Davis, you're for the father.
Yes, my lord.
Yes, why don't you call the... Yes, good idea. Just have the case called on before we get any further.
Okay, cool.
Have you called it on? It's been called already.
Sort of virtue.
Okay, sort of virtually. And then, Miss Manasseh, you're for the local authority.
I am, my lord.
And Miss Brooks, you're for the Guardian.
I am.
Now, there's been a flurry of emails passing various ways. First of all, people are asking permission not to be here. And your social worker is not here. Your client's not here.
My lord, no, she
She's had a...
yes, she'd intended on coming. She had a fall yesterday.
I'm sorry to hear that. Hope she's all right.
Intended to come, but contacted my instructing solicitor this morning, my lord, to say that she didn't feel able to travel to London this morning. So she passes her apologies. She does have the live streaming link and is joining to watch.
Okay. And then the Guardian also is asked permission to be...
She did, my lord.
And she's available. I hope that both she and the social worker are available on the end of the phone should we need them.
I've had her texting me already, my lord, and she's on the line.
Secondly, as you point out, this will be live streamed, so I think we should respect the anonymity of the child.
Yes.
So we'll refer to her as L, I think. That's right. And also try to avoid any unnecessary details which might identify the child or the family.
My lord, yes, I think we had discussed largely trying to use mother, father, foster carers and child or L to avoid any risk of identification.
The third point is that I asked that Mr. and Mrs. D, or one of Mr. and Mrs. D, as I'll call them, I inquired whether they were coming or whether they were going to be observing or contactable, and I think what I was told is that Mr. D is either watching or is certainly on the end of a phone. Is that right, Mr. Missy?
That's right, my lord. I have texted with him this morning. He's aware of the hearing. He does have caring responsibilities this
So he's looking after Elle at the moment.
That's right, because Mrs. D is working.
Mrs. D's at work, and
he's available at the end of the phone, and we've already exchanged text messages.
Right. Well, I'm very grateful to all of you I'm very grateful to your solicitors for that responding to my request yesterday afternoon. Thank you very much. So, Miss Fairclough, what have we got? We've got an appeal bundle. We've got which we've all read, and we've got supplemental bundles with skeletons from the local authority and the Guardian, and we've got the father's skeleton. Miss Davis, I think, is in the bundle. Then maybe there's duplication. We've got a small bundle of authorities. So that's what we've read. What I think we'd all like to know is the up-to-date position about Mr. and Mrs. D, because in Miss Melissa's skeleton argument, I think it's where it is, there is an towards the end of it, there's a reference to
8D. Yes.
Thank you. That's 8D. There's a reference to Mr. and Mrs. D through their social worker, considering what it says here is willing to show flexibility and wish to be considered as her adopters.
Yes.
So I think what we'd like to know is what the up-to-date position is about that. Were you able to tell us, or should I ask Miss Manassi to tell us?
My lord, I think Miss Manassi will be
Manassi.
able to assist. More
Okay.
in respect.
Would you mind, Miss Fairclough, if I, because we'd all like, I think, to know exactly what the score is
Yes.
on that, and also the other points about the adopters the other prospective adopters that you mentioned in that paragraph as well.
That's right. So just to say that I have asked for any further updates since the filing and service of this document. I'm not told of any other meetings that have taken place since the document was filed. I can certainly make further inquiries with the social worker who is available for him to respond to me as to whether anything else has happened. But as far as I know, the position is as per what is in the positions in the skeleton argument. And that is...
Well,
What does it mean? Willing
Well,
to show flexibility?
So the court will be aware that one of the issues that has been a block to further discussion with the Ds as to whether they would put themselves forward in respect of either long-term foster care or special guardianship or any other order has been a certain resistance to discussing what the financial package would need to be, if not what they are currently getting, and the need for reviews that would meet with the local authorities' need to review any package, including package of support, not pecuniary. And my reading of what I am told is that we are now at a point where they are potentially prepared to be more flexible in terms of what their expectations are. It is notable that even the Guardian, I think in her evidence, says that she was frustrated that they were not previously perhaps understanding the nature of the local authority's position in respect of that. And it may be that we are now on from that previous difficulty.
Well, just developing this for a moment, and Ms. Fairclough will forgive me, just as you're on your feet, there are a couple of points. The first thing I want to say, because it gets lost in this, is it's quite clear that Mr. and Mrs. D are doing an absolutely wonderful job looking after Elle.
Absolutely.
Who is a child with very unusual special needs, and everybody recognises that they are doing a fantastic job. And it's one of the many striking things in the judgment is the judge saying that she wishes she has a magic wand, and if she had a magic wand, she could wave it, which would find a way of enable the child to remain where she is. And that itself is a marker of how well she's flourished in their care, and that's not something anybody in this case disagrees with.
Indeed, and the local authority has commended them and has been very complimentary of their care and had approved them as prospective special guardians.
Yes.
Precisely because of the faith that the local authority has in their ability to provide that care, with the proviso that there have always been, and in fairness, there are likely to be issues with ongoing friction between the various sides of Elle's extended and direct.
In saying what we are saying, we don't lose sight of that. No.
Indeed. And therefore there would have been challenges
Yeah.
under whichever legal framework this child was going to be placed, if she was going to be placed with the Ds, as well as in any other placement where there was an ongoing parental relationship that would need to be managed.
Well, we won't forget that point.
No.
We'll perhaps come back to it in a minute.
But coming back to the fundamental point that the court raises, it must be absolutely said and again that the care that the Ds have provided is deemed by everyone to be, I think, optimum is the word that was used in evidence, and the local authority has not shied away from praising their care.
Well, that's, if I may say so, Mr. Manassi, that's extremely helpful and very creditable for the local authorities to acknowledge that. Just a supplementary point on this, and this it needs to be acknowledged that for Mr. and Mrs. D to look after a child like Elle, actually probably other children as well, particularly a child like Elle, has involved a very significant sacrifice because of, I'm not going to spell out what their jobs are, but we've read about them. They are both in employment, they both work, and they're both having to cut their working hours in different ways in order to meet L's needs. So I imagine that if L didn't need the degree of care that she does, Mr. D, instead of watching us on live stream, would probably be at work today. So it is a very significant personal financial sacrifice.
Absolutely.
And that leads on to the third point, which is the issue in this case has been about financial support.
That's part of it, and it's right that it's been a focus in the court below in the proceedings, but actually the evidence of the social worker and the guardian, I think rightly, puts it in its place in terms of the wider canvas of potential issues. But it is right that a lot of the evidence...
An issue, but
Indeed.
I'm going to say a significant issue, Ms. Manassi,
Indeed.
has been the financial. And I think what we would like to know, just to set the scene, if you can help us, is to flesh out what these financial issues are. So, can you tell us what the current rate, the current rate paid to Mr. and Mrs. D is as their agency foster carers, and what it would be if they were, I'm going to say, in-house foster carers, and then explain to us, if you can, how that would change were they to adopt L.
So first of all, I think I've set out in 2C,
Yes.
in the skeleton argument, the financial information that was available
Yes.
in the course of the proceedings in the court below.
Yes.
To my knowledge, nothing has changed.
Well, that is an S. That talks about an S. So the fostering, that figure there is what they are currently or were then getting. And is that still approximately the same?
So I'm not told that there's been any difference. I am assuming that there is no difference in terms of what they are currently getting. If that's not the case, I'm sure someone will text me.
Okay, so that's what they're getting at the moment.
So that's what they're getting at the moment.
So that's that monthly figure plus disability living allowance.
That's right.
So 3,000 a month, more or less.
Yeah.
And in terms of what would, if they were to be in-house carers, the figure that I set out, whatever the $390 per week, which is the rate for
in-house carers is in-house foster carers.
Correct.
Okay, so so that's about, I'm going to do a summary, that's about 1,600.
So where do you get that from?
390 times 4. It's a week, 390 a week.
So yeah.
I'm trying to compare.
So the special guardian rate is what?
So
The
that
fostering and fee, the fostering and fee allowance for for agency fostering is 270
plus
a month.
358.
But
that's right.
the
Special guardian rate is the same rate as in-house.
in-house foster care. That's what we.
That's
That's been
correct.
arranged. So that will be
Okay.
that's 390 a week. So times 4 and a bit will be about 1,650. Plus, they would also get the disability living allowance. Would they 350?
Yes.
Okay.
So they're about, and child benefit.
Yes.
And anyway, so there are, in very rough terms, are they about 1,000? It's about £1,000 a month less as in-house foster carers compared to agency foster carers.
That's right.
Approximately.
Approximately.
Okay.
That is the package that was available. I think if we're going to be more detailed than that, I think in-house foster carers normally don't receive the child benefits and other allowances, because normally what happens is that,
Okay.
or certainly as a special guardian, any benefits would have to be taken into account in terms
I
of the
see.
means
So
testing.
in fact, is it 1,600 versus 3,000 and a bit?
Yes, so the difference is significant.
Yes, it is.
But the more significant point the local authority says, the local authority having been amenable to discussing the financial package, is that the Ds had previously refused any prospect of review. And
Yeah,
any
I'm aware.
of the
I'm
Ds
aware of
assessment.
that. So just so we're clear, but just to spell that out, there is all these figures are reviewed on an annual basis,
That's right.
and the local, and I imagine they're set by regulation,
That's correct.
and the local authority would say we don't have any choice about this. You probably have some discretion around the fringes, but basically, your statutory obligation is your hands are tied.
That's correct.
Okay.
And the additional difficulty is, particularly coming back to the point of no review, which from the local authority's perspective is the anathema, if I am entirely honest with the court, they do not have the ability to bind the hands of a future head of service
No, quite.
in saying,
Well,
we will not review this forever and ever.
my colleagues who sit a lot in judicial review have no trouble with that at all.
Yes.
And that's obviously right.
Yes. And I think that fundamentally is the fundamental difference
Okay.
between where the local authority is.
Okay. Just I haven't forgotten Ms. Fairclough. We'll come on to the appeal in a minute. But just so, as what allowance, if any, would they get as adopters?
So there are financial packages that go with adoption. They are always bespoke packages. So there isn't as far as I know, a rate for what that would be. But, and I think the court has already guessed it, it would have to be subject to review.
And is it paid indefinitely or only for a limited period?
Again, there is, as far as I know, no limitation in terms of the processes of the local authority as to whether it would have to be limited.
And do adoption allowances take into account things like disability?
They do. And not only that, but I think a significant factor that I need to raise, if it's not already alive with the court, is that, of course, support isn't just financial support.
No.
It's support in all other
Absolutely.
respects, in terms of what the package would be in terms of respite, in terms of support by the Children with Disabilities team,
Yes.
in terms of practical considerations, as well as
Depends on the nature of disability. You have to have house alterations, etc.
Absolutely.
Respite care.
exactly all of that would be separate from any financial remuneration that they would get or any financial package that they would get. But the local authority views the whole package as integral to the success of a placement, and that's the case whether it's a special guardianship placement or a long-term foster placement or an adoptive placement, where the local authority has agreed a package of support.
Yeah. Well, that's as I understood. But thank you for spelling that out. Now, just before you sit down, we turn to Ms. Fairclough. What we know now is that Mr. and Mrs. D are willing to be flexible. That's as far as we've got, is it?
That's as far as we've got. It has to be said that until such time as we've dotted the I's and crossed the T's, it cannot be the case that the local authority would commit to a particular plan, because we are in some ways no further forward other than that we now have an inclination that these are prepared to be flexible. But the local authority is not coming to court today saying that this is the plan that it will follow, because it's still, without them having undergone that assessment and having agreed to the terms that the local authority considers integral, we're not in a position to say that this is the plan.
All right. Well,
This
thank
is
you very
exactly
much.
the position we were in the lower court, in that the local authority was pressed to say if the court declined to make a placement order, would the local authority guarantee that it would place the child with the Ds as a long-term foster placement? And the local authority was saying it is not in a position to guarantee that, because until such time as those are, as the placement is matched, and that it's a decision that the child is to be placed in long-term foster care with this family on the basis of X support, whether financial or otherwise,
Okay.
there cannot be a fully settled plan.
Okay. Well, I think we'll come back to that when we get to your submissions.
Indeed.
Ms. Manassi, it's extremely helpful. Thank you so much for filling. Any questions for Ms. Manassi? Any further questions? Okay. Thank you very much. Okay then. So, Ms. Fairclough. Now, just can I be clear about one or two things to start off with from you?
Yes, my lord.
What were the realistic options which the judge was asked to consider?
The judge was asked to consider return to mother,
Yeah.
long-term foster care with Mr. and Mrs. D, and adoption.
Right.
There had been the option earlier in the proceedings of special guardianship order, but that was not an order that Mr. and Mrs. D pursued, and withdrew from seeking the special guardianship order due to not being able to agree the financial package in respect of placement of L in their care.
Right. Now, it wasn't clear to me, reading the judgment, exactly what the options were.
Well, my lord, and Her Honour Judge Gargan, of course, also considered long-term foster care with other carers.
Well,
that wasn't a realistic option that was advanced on behalf of the mother, and I rightly acknowledge that given the reliance that I placed on the risk of moving L, that it is not a realistic option for her to be placed with unknown foster carers in preference to a plan.
okay. So it was not, was it part of anybody's plan? Was anybody putting before the court that it was a realistic option for there to be long-term foster carers with a different family? I ask you because it's not clear to me from the judgment.
My lord, no, the mother's case entirely rested on it should be returned to her or long-term foster care with Mr. and Mrs. D. And at no point was it advanced on behalf of the mother that it should be a plan of placement.
Was it advanced by any other party?
No,
This fact?
it was, I think, addressed on the basis that the local authority's position was, well, long-term foster care cannot be specifically with Mr. and Mrs. D. It can only be with an unnamed carer.
Implicitly, if not explicitly, it was on
Yes.
the table. Yeah.
Yes. And my lord...
So I see. So just to get, local authority was saying we can't guarantee that it will stay.
My lord, the case where the local case went slightly beyond that in relation to the matching, and I note the submissions that my learned friend makes in respect of the funding. My understanding in respect of the fostering allowance is that isn't set by statute, and indeed the agency fostering rates vary significantly. It was the local authority's case that essentially we can't match. We can't say whether we would match Mr. and Mrs. D with L because we couldn't consider matching until the finances have been agreed, and we couldn't match until the finances agreed, and we wouldn't consider that unless or until the plan was one of long-term fostering. So we were somewhat in this position of catch-22. We can't tell you we will match, and we won't consider matching unless or until there is that order. So that was the difficulty, and I acknowledge there is a difference between the fees of...
Looking at the judgment, can you show us where the judge spells out what the realistic options were? You've identified 3. Where does the judge spell those out?
Well, she doesn't specifically spell out at the outset. She addresses them at separate points. So she addresses within the judgment the issue of return to mother and concludes, in fact, in Her Honour's view, mother was not a realistic option for L to be placed with. That is, forgive me.
So what I'm looking for, bearing in mind the importance of not falling into the trap of a linear approach, where does the judge set out the realistic options, list them, and then go on to consider the advantages and disadvantages of each?
Well, my lord, she doesn't list them and go on to look at the realistic advantages of each. And my lord will know that that within my grounds of appeal specifically, I say that she didn't address the realistic option of placement with Mr. and Mrs. D as long-term foster carers. So that doesn't feature within that balance or analysis. and indeed the risks in respect
Well,
of.
my reading, when I read the judgment, I thought the position was that that Mrs. D had been ruled out, and that the options, the realistic options, wasn't a long-term placement with them, but long-term fostering elsewhere versus adoption. But you're saying that wasn't the case.
Well, my lord, I'm saying that is the error that the appellant, that I say on behalf of the mother, that Her Honour fell into. Is she concluded, I cannot say long-term foster care with Mr. and Mrs. D because I have no guarantee. That was in essence her conclusion, and led, my lord will see, and has referred to the observations that were made by Her Honour in respect of wishing to wave a magic wand
Yes.
to secure placement. And she concluded, in my submission erroneously, that placement with Mr. and Mrs. D was not an option, when in my submission, in fact,
It might have been.
It might have been, with greater pressing in respect of financial options, both as long-term foster care, or indeed, we hear today that there is greater flexibility being shown by Mr. and Mrs. D. My submission, that opens up not only the prospect of adoption by them, but potentially reopens the option of a special guardianship order with them if they are showing flexibility.
Well, I'm sorry to be. I mean, I'm trying to look at this through BS glasses.
Yes.
And the first thing is, what are the former president said, what are the realistic options? So to identify the realistic options, and then the advantages and disadvantages of each. So, is it unclear? Are you saying the judge did consider or did not consider placing the option of placing the child remaining in long-term foster care with the D's?
She did not
Consider it.
She did not consider. She considered the option of long-term foster care with with needing to move to other carers.
So she just so what her error was. What her error was. Her error was failing to consider it. Is that right?
Yes. Lord, how I put it in within the grounds of appeal is that she erroneously concluded that nothing else would do when she didn't in fact have evidence that long-term foster care was not a realistic option for Lucetta. In essence, she concluded that placement with Mr. and Mrs. D under long-term foster care was not a realistic option, and therefore did not include it within her analysis.
I've got the paragraph 28 for that, but where does she conclude that long-term foster care with the D's is not a realistic option? It may be implicit.
It's through the comments that it makes in respect of there being no guarantee of placement with Mr. and Mrs. D. The comments about if I could wave a magic wand for her to stay there, but it is not within my gift, I think is the comment that she makes in respect. And it is that I say in my submission is the error that she fell into.
Is it 55 that gets close to this?
Yes, she says, paragraph 55, that what I could not get from the local authority was a degree to which these current foster
That's for
carers
adoption,
would, in
though.
fact, forgive
That's
me.
for all
Yes.
long-term foster carers.
Yes.
As I read it, the passages at 57 to 59 were addressing the possibility of the D's as a long-term solution. I may have misunderstood because it's not very clear. But was the judge there saying that the social worker was being asked a whole lot of questions that she was not able to answer because she wasn't equipped with it wasn't her role, and she wasn't equipped with the data that she needed in order to answer them. And as I understood it, the conclusion was, therefore, it wasn't possible to say anything firm about the prospects of the D's being a long-term solution.
Indeed, my lord, and there are two further parts if my lord and my lady, so paragraph 121, which is A59 at PDF 61, if my lords are working electronically. So paragraph 121 of the judgment.
Okay. You said 57, 59, did you?
57, 59.
I thought that was more like the mother.
Yeah, well, maybe. It's in the context of the mother. Yeah.
I mean,
Paragraph.
just so we're clear about this, Ms. Faircliff, maybe it's not for you, maybe it's for others, but what the BS, we haven't got BS, you've given us BS, but from the top of my head, what it says is, that first of all, the judge has to identify the realistic options. And the judge has to spell out in clear terms an analysis of the advantages and disadvantages of each, and explain with a reasoned judgment why X is preferred over Y. That's what Sir James said. And furthermore, prior to that, the local authority and the Guardian had to provide evidence in that form as well, setting out the advantages and disadvantages of each.
Yes.
And I think, for my part, I think we're all struggling a bit to see where this reasoning is set out in this judgment.
My lord, that is probably implicit in the difficulty in identifying, that I, of course, am finding, identifying specifically the paragraphs, and indeed it is set out, in my submission, it's set out implicitly, for example, where referring to the losses, so when undertaking the balance in respect of the losses to L, Her Honour concluded that they are losses which is likely to suffer whether a placement order or a care order is made, implicitly that she would need to move.
So you,
so
121, as you
not,
say, the second sentence,
yes.
sorry to cut across years, suggests that really she has ruled out long-term foster placement that does not require a geographic move.
Yes.
Do you see what I mean?
Yes, my lady. And at paragraph 124, we're referring to the Guardian's analysis. She says, this, I consider the Guardian's balance is right, that if she cannot stay where she is, it must be a placement order. In addition, I recognise that does not mean she loses the immediate contact with her family. Again,
So that does mean she loses.
Yes, so that if she cannot stay where she is, it must be a placement order. Then in making a placement order, implicitly she has concluded that she cannot stay where she is, but without anywhere within the judgment undertaking the balance. And in fact, the extent to which she does undertake a balance of the risk of harm and the welfare balance for Elle and where she should be, the welfare balance she undertakes is that it would be in Elle's best interests to stay with Mr. and Mrs. D. It is in some ways a judgment in two parts that sets out what is best for Elle, and as my lord has already observed, everybody speaks of the optimum care that Elle is receiving with Mr. and Mrs. D, and that is set out very clearly. And then in my submission, the conclusion, because there is no consideration of Mr. and Mrs. D as long-term foster carers as a realistic option, there is an anomaly in my submission in the conclusion from reaching a conclusion that it is in Elle's best interests to remain with Mr. and Mrs. D. And whilst the local authority rely in their skeleton argument and relied at the final hearing on concerns in respect of a placement being disrupted, that is not something that is addressed within Her Honour's judgment as part of the analysis, because she didn't go on to undertake the analysis in respect of placement with Mr. and Mrs. D in long-term foster care. So had she undertaken that analysis, that may well have been a matter that she had considered, but she didn't undertake that balance and analysis, save that implicitly in my submission in reaching the conclusion that if she could wave a magic wand for Elle to remain where she was, that must, in my submission, imply that she had concluded that is the best place for her to be.
What do you say the judge should have decided?
My lady will see that the submission I made in the lower court was that she should have Her Honour should have invited the local authority to amend their care plan to one of long-term foster care, with the care plan reflecting placement in long-term foster care with Mr. and Mrs. D.
Sorry, just slow down.
Invited the local authority to amend its care.
Yes.
Then what?
To a plan of long-term foster care.
Yes.
With Elle remaining with Mr. and Mrs. D.
Yeah.
I, of course, acknowledge that the court can't micromanage a care plan, but that is a fundamental part in my submission of a care plan, and the court regularly, when considering alternatives of kinship carers, would consider a plan of long-term foster care with a specific carer. Where an SGO is not considered appropriate, the court regularly makes a care order to a specific carer where simply long-term foster care of itself might not have been a plan in the best interest. So in my submission, that is so fundamental to the care plan that it is a matter that the court could have invited the local authority to amend.
Yeah.
My Lord will see that with in mind the potential issues in respect of the matching and the fact that the local authority could not or would not confirm that L would be matched with Mr. and Mrs. D. I made the submission that the court could very clearly express on the face of the order the court's views in relation to L's best interests, and that if L were then moved, if there was an intention to move her for financial reasons, then there could be a judicial review application. And that was the case I advanced on behalf of the mother in the lower court as to how the court could secure L's placement in long-term foster care with Mr. and Mrs. D.
Well, judicial review is a very blunt instrument in this context. Anyway, so where do we go from here? We're going to go through your grounds.
Yes.
Yes.
Well, I've to some extent addressed my first ground, which was that the judge erroneously concluded that nothing else would do when she did not in fact have evidence that long-term foster care with the current carers was not a realistic option for L. So essentially that she had ruled out that as a realistic option. My Lord, in my submission it is clear throughout the evidence from the statement that my lords and my lady have from Mr. and Mrs. D, the statement from their supervising social worker, that these are carers who had been very clear that they would care for L under any order. Their commitment is to L. And in my submission, the starting point, therefore, is that the option of long-term foster care is then a realistic option. As I've set out in my submission, it cannot be the case that specific carers could not be considered as part of that analysis. Otherwise, it would preclude consideration of family members as long-term foster carers under final care orders. And my Lord and my lady will see that I have referred to specifically to the case of Re T, which I, of course, accept is not the same on the facts and related to a family member who had not yet been approved as a long-term foster carer. But in my submission, the point is similar in the sense that these are carers who had been approved as long-term foster carers, but the issue was one of matching. My Lord and my lady will see from the case of Re T the issue, and it somewhat leads into my ground too, in respect of the court should not have accepted the local authority's unchanged position without calling it into account for what was on the face of it an unconvincing response to a careful assessment of risk and welfare. And I do say, whilst a proper EBS analysis was not undertaken in my submission by Her Honour Judge Gargan, what to a large extent is undertaken is an analysis of the risk and welfare for L of moving, with an analysis that comes down on the fact of, as I've already set out, her best interests being to remain with Mr. and Mrs. D. Efforts were made during the course of that hearing by the advocates to get answers to those funding questions and the difficult issues in relation to funding. And my lords and my lady will see that those questions are at B73, which is at PDF 177.
B73.
B73.
Quite right for us, and it's on paper.
B,
Yeah.
for Baker. Whereabouts?
Sorry, B57, I apologise.
That's right.
But B57, my error.
Yes, yes.
And efforts were made to try and get answers to those questions in relation to funding, in relation to approval of Mr. and Mrs. D. Forgive me one moment.
So
And
the question, sorry,
Sorry, my lady.
my uneducated perspective, but so the questions go to the family finding team, the fostering team, and then there are answers from the safeguarding team, which is part of the family team, I guess, is it? So it's
Social work team.
social workers team.
Well, essentially, questions went to the local authority for the appropriate person to answer each of those questions. So the first questions were specifically ones that the family finding team would be able to answer. The ones set out then to the fostering team were some answered by the social worker, some from the fostering team, and then a number of the answers commenting that would be for the agency fostering team.
And
to answer.
does it work in this way? No questions go to the Devines, to the Ds.
No, no questions had gone to the Ds.
Right.
There was exploration particularly during the Guardian's evidence, of her discussions with Mr. and Mrs. D about their intention, and that centred around the challenges that there had been in discussing the finances. But the Guardian's evidence remained that they were committed to caring for Elle under any order, and that was essentially the D's position as it rang throughout the hearing, is that they simply love her and wish to care for her.
It's very difficult to do this sort of negotiation in the course of a hearing. And your point is that the judge should have one of your points is the judge should have adjourned.
My lord, yes, that the judge should have made further inquiries if she was not satisfied that it was a realistic option. If she was not satisfied that she had sufficient information in order to be able to place Elle in long-term foster care with Mr. and Mrs. D, then she should have asked further questions. And my lord will see within the judgment at paragraph 59, which is at A50 of the bundle. In respect of those questions, Her Honour said, I have a document, not in the bundle, a series of questions about the assessment and training process for doctors, about long-term fostering payments, means testing, adoption allowance, all the questions that really need to be answered in respect of the foster carers, and sadly so many of these are not detailed because they are either means tested and so answers cannot be given, or they're limited by the current guidance on the limitations on finances paid to in-house carers. So in essence, my lord, in my submission, Her Honour identified that there was information missing, and yet, having reached that conclusion, didn't go on to say, I need that information before I can conclude my analysis.
My lord highlighted paragraph 59, which you've now highlighted on. I read the whole of that section as being about the mother, but I do see that there is that passage about long-term fostering in 59, as you say.
And so fundamentally, my lord, I say, how could Her Honour conclude that nothing else would do when Her Honour herself had identified that the answers that she had were unsatisfactory and did not provide the information that Her Honour needed to reach her to undertake that analysis. and that links, my lord, to my submission, of course, that she had erroneously concluded it was not, that long-term foster care with Mr. and Mrs. D was not an option, because she didn't, of course, have that information.
It is very difficult. I think we can agree to work out how she dealt implicitly or otherwise with that option. But one possible analysis, I thought, is that she concluded that the risks to L of a long-term fostering arrangement were so great that adoption was the better, replacement for adoption was a better one. And that's where the D's got sort of swept up, because there was no guarantee, as she made clear. Then there would always be a risk of disruption, which would be a lot less under a placement order.
My lord, I would accept that Her Honour addressed that risk balance, but not in respect of Mr. and Mrs. D, and not on the basis of not just simply I have no guarantee. I would accept that taking into account guarantee in the longer term, it is a matter that would be appropriately taken into account, but the issue was no guarantee that she would even remain there in the short term. Indeed, the local authority were not even prepared to give a guarantee in respect of a contingency plan if an adoptive placement could not be found. So as it stands, Elle is in the position that if an adoptive placement is not found, there is no guarantee from the local authority that they would leave Elle where she is. And my lord, in my submission, there's a difference between balancing the risks of a long-term foster placement breaking down and the local authority saying we will not confirm that she can stay there. And I acknowledge there are always risks in respect of breakdown of a long-term foster placement, in the same way as there is always a risk of breakdown in an adoptive placement. The analysis Her Honour did not undertake is the difference in the risk of a breakdown in long-term foster placement if that long-term foster placement with Mr. and Mrs. D.
Well, you see, we come back to the point that I raised with you to start off with. What were the options? And I don't think the judge at the moment was considering the option of the placement with Mr. and Mrs. D. I think she ruled that out, as that's what she's saying at paragraph 121, supported by what she says at 124 about the Guardian.
My lord, indeed,
because I mean, if the child doesn't stay with the D, so the options are long-term fostering with a new family or adoption with a new family, then one can obviously see that adoption is, given the child has to move anywhere with all the risks that come from that for this child, one can see that adoption would be the preferred choice, or certainly the judge's decision that it would be unappealable. Yes. But you see, it comes back to the first point. Was the judge really looking at this? And you say she wasn't. Well, Miss Melissa says about it.
My lord, and that is my first ground for appeal. She did not consider that. And the other grounds essentially flow.
Follow on from that, they do really.
They flow from failure to consider that, because I've already, to some extent, addressed the. And my lord, would, in relation to that first ground, would it assist my lords and my ladies for me to deal with that ground any further?
Well,
observations.
I think we've got your point.
Could I just follow on my lord's point? To what Miss Manassi will say, but I'm just looking at the response to this aspect, in particular, page 6, paragraph 7 of Miss Manassi's very helpful skeleton argument. Point of detail at A, you can help us with, but B would seem to confirm what we've just been discussing, which is that the D's were really treated as being out of the picture on the basis of what was then crystal clear, and what is now not so crystal clear because of the introduction of flexibility. Do you have anything to respond to in relation to A and B? You didn't apply for any adjournment based on further financial information.
My lady, no, on the basis, the point I was making in the local was the court had sufficient information to be able to say the right plan for Elle was long-term foster care, and to invite the court to amend its care plan on that basis.
Right.
One of the arguments that I advanced in the lower court was that it was simply unfathomable, if I put it that way, that a local authority, with a court concluding that it was in a child's best interest to remain in a placement where they were, would not match a child based on finances, where it's an amount that they are already paying in a long-term fostering allowance. So it's not the same as agreeing an adoption allowance. It's not the same, by submission, as agreeing the special guardianship allowance. Mr. and Mrs. D were simply saying, our fostering allowance to continue. So to suggest that any child ought to, in my submission, suggest any child ought to move from a placement and then suffer harm by that move based on finances, in my submission, is entirely
Well, that's the standout feature here is the particular difficulties for the child in arising out of any move. But just second follow-up point for me is in relation to what you were making submissions about risk. Can I make sure I understand that what you're really saying is that, of course, in many ways, the local authority can give guarantees or confirm, but standing back, being realistic on the facts, what are the chances of the local authority requiring the child to be moved? You say in real terms, the court could have been in a position to say it's not going to happen.
Yes, my lady, and indeed the social worker's evidence was it's not our plan to move her, but I can't guarantee it.
Yeah, but you can never say never. Say never.
Well, a care plan covers this. A care plan says this is the plan. The plan, and it ought to be able to say the plan is for this child to stay in this placement. But there's always a contingency. This comes on to another point of yours. There's always all care plans contains a contingency, because it can't be guaranteed in long-term care that the child will remain where she is. So there has to be a contingency plan.
Yes.
And the plan should be, ordinarily the plan should be sufficiently clear for the judge to be able to make a confident decision on the back of knowing where the child's going to be.
Yes.
Not in every case, but in a case like this.
My lord, and it in some ways comes back to the issue of the catch-22. But in my submission, everyone could be satisfied standing back and looking at it objectively, that if the court had concluded Elle's best interest to remain where she was, approved a care plan for Elle to remain where she was, the prospects of Elle not then being matched with Mr. and Mrs. D, if the care plan is for her to remain with Mr. and Mrs. D, is extremely unlikely.
Well, yes.
That senior managers would say, we will not match on that basis.
Well, I've known cases where local authorities dig their heels in on this, but usually they don't. Usually, by the time the judge makes the decision, the local authorities have gone through whatever processes they need to, so the court can be clear that if it makes the long-term foster care or care plan approving long-term foster care, where the child, if the child's going to be moved or to stay in its current placement. But it comes back to this: is that what the judge was doing here? Was the judge really considering long-term foster care? At the moment, not with the D's. At the moment, it's not clear to me that she was.
And my lord, the local authority's case was Mr. and Mrs. D could not be considered as an option. That was the local authority's position.
Well, yes. Well, that's how I eventually read the judgment. That there wasn't a realistic option, but you wrote it openly and you said that was the option she was considering.
Well,
anyway, we've been around this track.
My lord, and that is probably me. That was an option that was advanced on behalf of the mother as being a realistic option, and that's why I put it in that way as the options I say.
Where do we find the judge dealing with your client's consent to adopt the placement order?
My lord, I don't think it appears on. There is a portion in the transcript of the judgment which I think we received last Thursday.
It's 128, but it's just a sentence at the end.
Yes.
What does it mean in the circumstances of the case demanding it?
Just one sentence.
Just one sentence. There was, you'll see in my skeleton argument I'd referred to then, I'd asked amplification questions. Clarification in respect of the dealing with the option I had put before the court. That doesn't appear on the transcript. To say that was only received by us, I think, on Thursday.
Well, have you got an agreed? Do you ask for clarification?
I asked.
And have you got? Did you get clarification?
The response, and I set it out in my. Skeleton argument. To be clear, my lord, the clarification question asked wasn't in respect of the dispensing with my client's consent. It was in respect of the option that I had put before the court of inviting the local authority to amend their care plan. And the response was that everyone could say no more than she had already said.
Yes, that's right. So all she's ever said about consent was the very last phrase. And well, how does that meet the statutory test, which I'm just going to remind myself of? It's if the welfare requires it.
Yes.
It may be said against you or against my point, but that's implicit in that's what she must have meant. The circumstances. I see Ms. Menassi nodding to that.
Well,
we'll go back to you in a minute. But is that what do you have any submissions about that?
Well, my lord, in my submission, as is the case throughout, in my submission, the judgment, there is a lack of analysis of all the options to consider whether it was necessary to dispense with the mother's consent on welfare, because she, and it comes at full circle essentially to not considering all of the options, and particularly when Hannah had concluded that if she had a magic wand, it would be in Elle's best interest to remain with Mr. and Mrs. D. So it begs the question how the conclusion is reached that it is necessary to dispense with my client's consent to adoption, where that adoption would remove Elle from the placement, where everyone agrees her care is optimum, and where Her Honour concluded it essentially would be in her welfare best interest to remain. My lord, I do of course say that this is a case that is exceptional on its facts. Elle is a very unique child with very specific and significant needs, but in particular significant risks arising from her being moved.
Yes.
The family finder accepted within the note of evidence at A66 that there would be an emotional and physical risk to her, and Her Honour concluded, Her Honour herself noted the risk to Elle if she is moved, noting that if, and it doesn't overstate it to say it is a risk of death.
Yes.
In my submission, Her Honour it was erroneously concluded that it wasn't in her gift to secure placement or wave that magic wand.
Yes.
And I do say that in respect of considering where there is an analysis and considering the impact of the losses, Her Honour was wrong in concluding that those are losses that would be experienced whatever, whether she made that an order for approving a plan of long-term foster care or made the placement orders, because the risk of the losses if she were to remain with Mr. and Mrs. D was not the same, and that wasn't, but fundamentally in not undertaking that balance, she wasn't able to consider.
Well, the more we go on, the more I'm personally convinced she didn't consider that. She ruled it out, and she dealt with the case, and she said she did it 1-2-1.
I think in respect of my second ground of appeal, in relation to financial information, I think I've addressed most of those issues whilst addressing.
Yes, well, I think you've probably covered all your grounds, haven't you?
My Lord, yes. In relation to that information, as I say, I would simply say that how could Her Honour conclude that nothing else would do without that information, as I say, when she herself had identified that gap. There is an observation within my learned friend for the local authorities skeleton argument at 7B that it is said that at the time of the hearing, the Ds were crystal clear that they would not consider putting them forward for matching in those circumstances. In my submission, that's not accurate, and their position remained throughout, as far as all the parties were aware throughout the final hearing, that they simply wished to care for L under whatever order they could care for L. And they, when one looks at the chronology of their first statement is in May, where they detail the consideration of long-term foster care, that it had been made clear to them that wouldn't really be an option, and the consideration of the special guardianship order at that stage. But in my submission, there was nothing through that hearing to suggest that in any way Mr. and Mrs. D would not go forward to a matching panel for L. The separate ground I rely on, my lords and my lady, that doesn't quite overlap in the same way to the others is ground C, that the learned judge failed to undertake an analysis of firstly whether adoption was in fact a realistic option in the case in light of the evidence of the family finder, and secondly the impact of delay on L if an unsuccessful search is undertaken.
Well, what Ms. Manassi says in reply to this is that you're simply wrong on the first point, because there was evidence in which the court was informed that there was a realistic prospect of finding carers, and looking at what's happened since, that would seem to bear that out.
What the court was told is that it was possible, doable, likely to take more than 6 months to identify, and there was lengthy evidence for
12 months would be given how Miss Manassi puts it, in 12 months possible to identify.
Possible. Oh yes, and the in my submission where I say that in considering that option, this is that the longer L remains with Mr. and Mrs. D, of course, the greater the impact on her.
Well, I mean, the value judgment, the judgment the judge made here was, and this was separate from your main points,
yes,
the points you'll be debating. So this is that a period of whatever it is, 9 to 12 months, I think she said, didn't she? Was fined. After that, they'd have to abandon the search.
Yes.
You say she was wrong to give them that time, assuming that she was right to go down this track at all.
Well, of course, I say she was
not right to go
down that track.
You've raised this alternative ground, so you say she was wrong to. You say that even that was wrong, do you?
Well, my lord, I accept that there is now the additional information that there are some potential matches that have been identified. The court heard of the very limited number of placements, and indeed it not then simply being about availability of carers, but the right carers for L. And one issue that Her Honour did not address in considering it being a realistic option in relation to identifying the family is the particular needs of Elle, the pressure on adopters who, of course, do not know her care in the way Mr. and Mrs. D do know her care, and then in my submission, the impact that then has on the risk of placement breakdown, or indeed willingness of initially identified adopters going through with the match. I acknowledge it is not my strongest point in respect of the grounds that I've put forward.
Thank you.
In relation to ground D, failing to undertake a balance of the risk of breakdown of an adoptive placement against the risk of placement breakdown with these particular carers, as opposed to long-term foster carers in general. I think
we've covered. Ms. Fairclough, I think we've covered the remaining grounds of that you've put forward. They all really roll up into the principal ground, don't they?
They do, my lord. In respect of that ground, I would say that, of course, there was a particular need to consider to balance the risk of breakdown in an adoptive placement with the risk of breakdown in the care of if Elle were to remain in the care of Mr. and Mrs. D, because of the commitment that they have demonstrated, the experience they have in caring for her, and knowing what they are, what her needs are, and indeed given her that she is already invested in their care. And my lords and my lady will have read the issues that were raised and the difficulty mother had in managing the fact that Elle calls them mummy and daddy, and to Elle's mind they are mummy and daddy, because they are the carers she has been with since the point of her leaving hospital.
Yeah, Ms. Fairclough, I think you can be fairly confident. We see the clear advantages of the placement with Mr. and Mrs. D.
Thank you, my lord. In respect of contingency plan, again, I think I've largely addressed that.
Yes.
With an absence of contingency plan or willingness to commit to a contingency plan. Can I assist the court any further at this stage?
Thank you.
Thank you very much, Ms. Fairclough.
My lord, on the question of what realistic
I just
options-
wonder whether you would, in fairness to you, Ms. Manassi, we should hear from Ms. Davis, who supports the appeal,
Yes,
before we hear from you.
that's fine.
Unless there's anything you were bursting to say to help by way of clarification.
One thing I think will assist the court is that I think it's been put to you that the realistic options were not set out by the judge, and I think I have found the paragraph where she sets out the options being, and that's paragraph 99 at A56, I believe. The options being
Just a moment. 56.
return to parents, placement order, or long-term foster care, i.e. not with the divines.
Yeah.
And I would say that she's accurate in setting out that those are the realistic options, because if it's not open to the local authority to guarantee a placement with the
Well, you'll
divines,
come on to your submissions in a
But
moment,
yes.
but thank you for pointing that out to us.
Paragraph 99.
99, Ms. Manassi says. All right. Ms. Davis, thank you very much for your skeleton argument. What do you want to say?
Thank you, my lord. Well, I really intend to briefly supplement the submissions made by my learned friend, Miss Fairclough, who's covered most of the ground that I would have covered in that sense. One of the points that I would like to raise for the court when looking at the analysis of the judge is that one thing that is quite striking in her evidence is she talks about giving the child a chance at adoption. But adoption is not a chance, it's a last resort option. And that's one of the things which in the judge's judgment, the father would say, it is really quite striking. She approaches long-term foster care and with the Mr. and Mrs. D and adoption as not equal options, but she discounts Mr. and Mrs. D because there's no guarantee. But in the face of evidence about the scarcity of potential adopted placements, she doesn't view the lack of guarantee in that in the same way.
Well, just to help me, Miss Fairclough told me, that I asked her what the realistic options before the judge. Miss Fairclough told me that they were return to mother, long-term foster care with the Ds, or adoption.
Yes.
Now, it wasn't how I read it, And Ms. Manassi has drawn attention to paragraph 99. What do you say the realistic options put before the judge were?
Placement order, placement with the Divines under long-term foster care, the D's, under long-term foster care, and
Return to mother.
return to mother.
Okay, so you agree with Miss Faircliffe as to the options put before the judge?
Yes, that was certainly the tenor of the submissions made, and the lack of real analysis of those options, or the lack.
Do we have the written submissions? We don't, do we?
There were no written submissions, my lord. They were oral.
Well, what about position statements? The start of it. Were there position statements filed at the start of the hearing?
There were, my lord.
And did they set out the realistic options for the judge?
I can double check, my lord.
Well, perhaps you could check, maybe over the German or whatever. I'd like to know what, because it would be quite wrong for me to criticize anybody to criticize the judge if they weren't put before her in the way that they should have been. But anyway,
Thank you, my lord.
so your position is that the options before the judge were as Miss Faircliffe said.
Yes, as I recall, the way submissions were structured were setting out the preference order, if I may put it that way, of the parents, beginning with return home to mother, followed by long-term foster care with these particular foster carers, and finally adoption. And certainly the tenor of the submissions made on behalf of the father at the original hearing focused very much on long-term foster care placement with Mr. and Mrs. D. Much as of what could be said for the mother had already been said on her behalf.
Okay.
And really, as I think potentially my lady and my lords have picked up, that there wasn't really an analysis of either why this placement option of long-term foster care with Mr. and Mrs. D was either discounted by the judge as not being realistic, or why it was a realistic option but preferred over adoption. It's just not clear at all from the judgments. And to be fair to the learned judge, it was a very emotional hearing and a very emotive issue for all involved professionals and the judge herself. But indeed, when considering this very important point, it was put to the judge whether she'd like to hear from Mr. and Mrs. D during the hearing, whether anyone wanted to challenge anything in indeed their letters to the court or the statement from their social worker, which set out effectively that it had become a long-term foster placement. I think that's in the bundle at B76. And no party wished to challenge those assertions made by either Mr. and Mrs. D or the social worker on their behalf. But really, my lord, I adopt the submissions made on behalf of Ms. Fairclough.
We've got your helpful written supplemental submissions.
I don't want to take up too much of
No,
the
well,
time. In the
is
interest
there
of
anything else
brevity.
if nothing else you want to add at the moment?
No, my lord, unless I can assist the court any further.
Do you have any questions for Ms. Davis?
No.
Thank you. Thank you very much, Ms. Davis. So, Ms. Manassi,
Yes.
thank you very much for your written document, which has been very helpful. But I'd like you to, you've already hinted what you're going to say, but I'd like you just to confirm what you say the realistic options before the judge were.
Yes, and it strikes me that we remain ships passing in the night in terms of our understanding collectively at this end of what is open to the local authority and by extension to the court.
Well, my question is, what were the realistic options which the judge was considering?
So, what was properly open to her, and she, in my submission, properly considered, was the option of return to the mother because the father was supporting of the mother,
Yes.
long-term foster care, or the making of a care and placement order with the plan of an adoptive placement being identified.
Long-term foster care, full stop.
Long-term foster care, full stop. And the reason for that...
And adoption,
That's right.
full stop.
Correct. And the reason for that, as is in my submission entirely proper, and the judge did not err in this, is that if it is not open to the local authority to guarantee ongoing placement with the Ds, and the evidence of that from the social worker and the guardian is, if I can summarize it, that many things go wrong without anyone being unreasonable in terms of long-term foster placements breaking down over and above the reasons why adoptive placements break down. There was no guarantee that the local authority could give, even if the financial package had been resolved, that it would be a placement that would be the long-term placement.
But
Why
surely,
not? Why not? Sorry.
no,
Well, indeed, only in that the position of the local authority was that, if, first of all, long-term foster care would not meet L's need for permanency, and we've had lengthy evidence and discussions in the court below as to what that means.
You've shifted the question, I think.
Well, not entirely, because the difficulty is that the idea that is being put to the court and was put to the court below is that permanency in that long-term foster care is a permanent placement plan, and the evidence was that L would have lifelong need potentially for carers to be proactive and advocating on her behalf.
You had a question. What's your question?
yes, my question was, we raised this with Ms Fairclough, but yes, no guarantee, but does that mean you ignore the Ds altogether
It doesn't.
from the exercise? So surely one realistic option had to be long-term foster care, not full stop, possibly, or even probably, with the Ds.
Well, the difficulty is with that we had already at that point had, I believe, lengthy discussions, including the offer of mediation, with regard to a number of matters, not just the financial issue. And they'd had the offer of legal advice. And in fact, I remember in the evidence of the Guardian, where she had suggested further legal advice, and the judge says, would further legal advice help? And the Guardian's evidence was, really, there's no point. It
So
wouldn't
they
help
had legal
anybody.
advice.
They'd had legal advice certainly offered to them. I'd have to double check whether they actually took it up.
They had 1 hour.
had
of
1
legal
hour.
Advice.
Yes.
1 hour.
Yes, the standard offered to prospective carers and care
1 hour.
Then they had the offer of mediation, which I believe was not taken up.
Offered. Mediation. Offered.
They had significant levels of discussions with regard to attempting to explain to them the difference of where the local authority was coming from in terms of the issues with the financial support package. And my understanding is that the Guardian also attempted, and I think it was her evidence that she also attempted to have those conversations with the Divines. The evidence of the social worker was, she was asked, have there been discussions? And she says many times.
Okay. But
So-
okay, let's just take a step back. It's perfectly possible, and indeed, in my experience, the norm, if if a child is with long-term foster carers, or has been with, and the hope, the intention is that she'll remain there, if that's what the plan is. Local authority draws up a plan which says in terms, the plan is for the child to stay with Mr. and Mrs. D, or whatever, with a contingency plan if things go wrong. All sorts of things can go wrong with long-term fostering, and you have to have a contingency plan.
That still presupposes matching. So they would still need to have, in principle, accepted the need for the ongoing review,
Yeah.
which is one of the significant sticking points.
Okay, this isn't what happened in this case, but what would I would have thought that the judge would not make a final care order until the matching had happened.
So the matching actually happens after. So in terms of the procedure of it, the matching is the decision that this is where this child will be placed now that the decision has been made for a child to be made subject to a long-term, to be placed in a long-term placement with this particular set of carers. The problem with that, and I think the Guardian alluded to this as well, is that if everybody had been working collegiately towards that outcome, we wouldn't have had a contested hearing about it. There would have been a consent order some period
Well,
before.
the parents could have objected. So, I wouldn't make a care order without something guaranteed, frankly, Miss Manassi. More than that, I wouldn't have made it. I mean, you may be technically right that a sort of final matching wouldn't have been formally agreed, but there would have to be a clear care plan before the judge saying the local authority intends the child to stay here.
But I think what is potentially unsaid in that judgment is that neither the social worker or the Guardian considered that it would be in L's welfare interests to be made subject to a long-term care plan with the Ds because of not just the financial issues, but because of the other matters that were potentially going to be of relevance, but perhaps understated in a document that is likely
Well,
to be seen
you
by
see,
the child.
you this is what did you say? Potentially unsaid in the judgment.
Understated.
Understated in the judgment.
I think that what the judge says delicately is that, if not a campaign, there was certainly a pattern of issues with the birth family that would have required ongoing
Well,
management.
that's it.
That-
You're so right.
and the legal
I think
framework-
understated, if I say this, is exactly the right way to put it. There's certainly a flavour of that, but it's not clear.
Yes.
And this is the main problem I've got, so far as you're concerned. For my part, I've got, so far as you're concerned, Mr. Manassi, is that this judgment doesn't meet, in my view, the requirements of BS in terms of being a clear statement, an analysis of what are the realistic options and what are the pros and cons of each.
So, just to break
It's
that down,
it's a very complex case,
and it's delicate.
and the more complex, the greater the need for clarity.
Yes. So, just to break down in terms of what was properly before the court, the local authority submitted and continues to do so, that it is not open to the court below, and my submission not open to this court here, to effectively substitute the decision with a care order with a view to a particular placement. And the reasons for that are, first of all, the evidence is right, that the evidence is that the Ds have been providing optimum care, but not that legal framework, i.e. the framework of a long-term foster care, would have been optimum in the long term. For some flavour of this, the court will have seen issues to do with friction, issues to do with contact, and issues to do with misunderstandings, and how that might affect L, and how contact with L potentially put
Okay.
her at risk.
But this is
of emotional harm.
but your case is that the judge wasn't presented with placement with the Ds as a realistic option.
Well, I would say that it was put to the judge on behalf of the mother and the father, and the local authority said very clearly, if it is not an option that is open to the local authority to guarantee, the court cannot make a care order on the basis of that being the plan, for the reason that, first of all, any head of service, as the Guardian says in her evidence, any head of service could override any decision with regard to financial support.
Yeah,
if
but
it is
that's not how
subject
it
to
works.
review.
See, the local authority puts forward a care plan, saying this is what we're going to do.
Yes.
And unless the court is happy with it, it won't approve it.
Yes. So just to clarify, the position of the care plan was for Elle to remain where she was until such time as she was placed in an adoptive placement. So, and the social worker was pressed. What does that mean about if no placement is found? And the social worker said quite properly in my submission, I'm not able to say. And this goes back to the fact that unless a placement is matched, and that presupposes agreement on all of those different issues, it is not a plan that the local authority can approve. So there's nothing in my submission wrong about the local authority's position on that, or the judge's understanding of the local authority's position on that. What I understand the court to be anxious about is the possibility that that Elle might have remained there under a long-term foster placement, and that, in my submission, is obviously what the court considered, because that was going to be one of the realistic options if there was no adoptive placement found. And the judge you'll have seen the judge says, I implore the local authority to move heaven and earth if no adoptive placement is found, for her to remain where she is. So it's clearly in the contemplation of the judge, and she has, in my submission, gone as far as it is possible for her to have gone in terms of the language that she has used and the emotive language that she has used, to implore the local authority to use its best endeavours to keep Elle where she is if it is not going to be under a different legal framework.
Right. So we've got the position where two of the parties have told us that the realistic options put before the judge were A, B, and C, and you're saying that the realistic options were A, C, and D.
And in my submission, this is, I think, indicative of how I describe us being as ships passing in the night, because it being put forward to the court below and to this court that it is a realistic placement option for the court to have considered when it was not something that could be guaranteed.
Okay, well then the first thing the judge does is identify the realistic options. So where do we find that in the judgment, do you say?
So in my submission, you're right, it is not set out explicitly, but paragraph 99 explains that the judge accepts that the options are the three that I have set out, and that's only because, not to discount the possibility that Elle might remain with the Divines under long-term foster care if things work out all right, but to say what is available and properly open to the court to choose from. Those are the options that are open to the court.
Can I ask a question about the level of commitment that the Ds were expressing
Yes.
at the relevant times, starting with your skeleton argument in paragraph 2I, page 3 of the skeleton. You give an account of what they had repeatedly informed the local authority. Which I read as being, unless we get a guarantee of financial support without review or means testing for the entirety of her minority, if I can put it that, we won't pursue the option that is said to be realistic. Now that, if that's right, we don't have the document, but that's what you tell us. If that's right, it seems to be quite an important factor.
Well, they
As a
withdrew
non-specialist
from...
in this area,
Yes.
in considering whether it's a realistic option.
Well,
Given that you say the local authority couldn't give that guarantee.
that's right. And they withdrew, they withdrew from the plan of a special guardianship order because they would not accept what the local authority was saying about A, the money, but B, the reviews. And the local authority potentially would have been able to do more with the money side if the review had been agreed.
And can I just ask,
Discussions
sticking
have been
with the
very
facts?
clear with them, is my understanding, that the review is the sticking point.
Yes, well, going back to the skeleton argument, paragraph C, subparagraph C of the same paragraph, at an earlier stage, it seems to be in July of 2021. We've got lines 7 or 8, Mr. and Mrs. Divine stated, and then there's a quote where they're really explaining why
Yes,
they can't make that commitment. To me, totally understandable.
indeed.
But was that consistently their position?
Their position has been
Up to
consistently...
the point at which the judge was making her decision.
Well, it is right that their decision has been we will care for her under any legal framework, brackets, as long as we continue to receive our fostering allowance without review.
Yes. Well, as
That's
I
the-
say, I
that's
want to be
the-
clear. I'm not, just like the judge, I want to be clear that this is not a criticism of them for being money-minded.
No,
It's
they
perfectly
were-
clear that that's not
And particularly within the
a
SGO
fair way of
framework.
characterising it, but
Yes.
to me it's completely understandable that they would not
Yes.
want to take the financial hit.
It's multifaceted in the sense that they are precisely the people that the relevant regulation has in mind when it says if a foster carer applies for a special guardianship, they are going to lose effectively that income. So they need to have that guarantee of an income in the fostering, in the special guardianship sense.
Yeah.
Exactly. And to go further than that, they are specialist foster carers. They have done training. They have made life choices as to what work they will take on in order to make themselves available for this highly specialist area of work. None of which is to say that the local authority could have authorised a plan, whether under special guardianship or any other legal framework, without there being any reviews.
Yes, okay. Well, on the reviews point, for my part, I think we needn't trouble you further on that. It's very helpful because that was their position, as my lords highlighted. But I want to go back to paragraph 99,
Yes.
if I may, because you say that in paragraph 99 of the judgment, that is where we see the judge saying, effectively, the options are as you say they are,
Yes.
and not as
Correct.
Miss Fairclough
That's
and
right.
Miss Davis.
And it may well be. So I think what the court is getting at is that how can the court below have properly analysed all of the options when it discounted the possibility of long-term foster care with the Ds as one of the realistic placement options? And I would agree with my learned friends that if this court found that that was one of the realistic placement options, properly open to the court below, then it may be said that the analysis is lacking.
Okay, so
But, however,
let me just make a note before you go to however. If Miss Fairclough is right, and it was a realistic option,
that was properly open to the court below. And I say that because my submission is
long-term foster care with the D's.
correct.
Then you would say that arguably, I think you said,
Arguably,
the analysis is
lacking. But I want to address you further on that because
okay.
in two respects. One is this judge had continuity since 2020.
Yeah.
Had been involved with all the bitter history of the discussions, had been fully aware of the issues, had permitted the extension of the court timetable for further assessment.
You knew what she was very familiar with the case.
She was very familiar with the case.
Yeah.
The evidence that the court considered, in particular the Guardian's evidence, was the frustration that, as the Guardian put it, that they're not seeing that it's not a negotiating stance by the local authority, is the Guardian's words, to say that they require reviews, is my addition.
I'm sorry, say it again?
The Guardian's evidence on this, which the court accepted, is that the Guardian was frustrated with, with the Ds, because they could not see that what the local authority was saying, I say about the review aspect, is not a negotiating stance by the local authority. Whether they had fundamentally misunderstood what was properly open to the local authority to offer to them, and why.
Yes.
And the judge would have been acutely aware of the history. The judge would have heard evidence, the judge heard evidence on this issue from the local authority and from the Guardian in terms of the ongoing efforts that were made. The judge was driving a lot of the questions in respect of this evidence.
All right.
And so
now,
I would say that...
I'm sorry. Finish your sentence.
Sorry, I would just simply say that yes, it is right that if it was an option that was properly open to the court below, then arguably the document of the judgment potentially could have been more clear in its analysis. But I say that it cannot be argued that those matters were not at the forefront of the judge's mind.
So you've said a number of times properly open to the court below.
Yes.
Do you consider that things have moved on since then, and if they have, do you say we should ignore those developments?
Well, the starting point is the local authority's evidence, and the Guardian supported this, is that long-term foster care, whether with the Ds or not, is not in this child's welfare interests, because the Guardian was concerned about ongoing corporate parenting, decisions being made by...
Quite a narrow question, just as a matter of principle. Do you say there has been a material change of circumstance since the position before the judge, and if there has, are we to ignore it or do we take it into account?
So first, not in respect of whether long-term foster care is a realistic placement option for this child. The change in what has happened since arguably is relevant to my learned friend's second point in her grounds, which is to do with how realistic it is to permit a search for an adoptive placement, because there's now potentially 2 other placements as well as potentially movement with the Ds. But that's not, in my submission,
why is there
relevant.
Why has there been no material change in terms of the prospect of long-term foster care?
Because first of all, I disagree that there was, by anyone, ever a plan for long-term foster care with the Ds as a realistic placement plan. So what I mean by that is, if the legal framework was never going to be right, for various reasons that perhaps the judgment is
the understated aspect.
Understated. But it was never going to be the right placement plan for this child under this legal framework. And therefore, to say that they are now more flexible with the aspects of the support package does not materially affect...
Well, we don't know, do we?
Well,
do we?
It doesn't...
I mean, being more flexible could mean anything.
It doesn't, in my submission, it doesn't materially affect any of the other aspects that make this legal framework suboptimal for this child.
Well, state what was understated. What precise other legal aspects are not capable of cure by a more flexible approach?
Well, my understanding is that they are suggesting that they're likely to be more flexible in terms of the financial support aspect. The local authority's concern and the Guardian's concern was about friction to do with contact, to do with managing parental involvement and managing parental...
Friction with the family.
Friction with the family.
Yes, and...
With managing, conflict. I think everyone has strong opinions on all sides as to what should happen. I think the judge has alluded to that in respect of the mother in her in the judgment. It's also right that the Ds have put themselves forward indicatively to be assessed at the point when they thought that the maternal aunts were going to be potentially putting themselves forward, thereby, I would say, indicating that they had strong opinions as to what should be happening with Elle in the long term. That's just an indication that is perhaps, again, understated in the judgment, but is something that the court would have been aware of in terms of the dynamics. You will have picked up that the maternal aunts were respondents and had said, before they changed their position at the last minute.
I'm just not following what your in answer to Malena's question. What else what does the commitment to flexibility from the Ds not address? You said
friction with
yes,
the family.
it addresses the financial issues potentially,
Yes,
but not
yes.
friction with the family. Then conflict.
Contact.
Contact. Oh, the contact.
Yes.
All right.
Because the problem with contact is the first issue is how much contact is in Elle's welfare interests. The Ds, I think, have views in respect of well, they've set out they have views in respect of that.
Yes.
That's set out in my skeleton argument. The second point is that at contact, the court will have picked up that occasionally one of the concerns is whether the mother says things that might be upsetting.
So what you're just saying, you're saying that if one was to consider the commitment to flexibility about money does not address all the concerns which the local authority has.
That's right.
And the Guardian perhaps about long-term fostering with the Ds.
That's right. As a legal framework.
Okay.
The difference being that under a different legal framework, the same placement might offer all of the advantages and fewer of the disadvantages of what otherwise would be the local authority's concern if the legal framework was long-term foster care.
Let's go back to paragraph 99,
Yes.
which you say is where we see the judge not clearly, but sufficiently clearly,
Yes.
you say, in an understated way, setting out the options.
Yes.
And she does it by reference to what she's talking here about what the Guardian said, isn't she?
That's right.
So what she says is, 97, 98 talks about disadvantages of long-term care, lack reviews, not lack of permanence, 98. 99, therefore the idea of a child with L's potentially having multiple moves just doesn't bear thinking about. The idea of a child moving from foster placement to foster placement. If there was any way that they knew she could remain with the Ds, that would be different. If there's any way there could be a special guardianship order and stay in the placement she's in, that would be different. If there's any way they could adopt her, that would be wonderful. However, the idea where she, as a guardian, is dealing with only the three options, return to parents, placement order, or long-term foster carer for a child of this age, she felt very clearly she had to give this child a chance of permanence.
Yes.
Okay.
And that's a
leave
whole other discussion with the...
Leave chance for the moment. Don't worry about that.
Yeah.
But you say that is where the judge is saying, by reference to the Guardian's analysis, have I got this right?
Yes.
1, return to mother. 2, long-term fostering generally, not with the Ds, but with a move.
Yes.
And C, adoption.
And just to clarify, it was always open and in the contemplation of the court and the local authority and the Guardian that the outcome in the long run may well be that if adoption is tried and it is not identified, that at that point the local authority would have to review its options, and at that point decisions would have to be made.
Yeah.
And at that point it may be that the Ds were a realistic option if adoption had been tried.
But let's just focus, if we may, on what the judge is saying is that's what the Guardian is saying. If I look at the Guardian's report, I'm not sure that's right. the Guardian's report seems to analyse long-term fostering with the Ds and not generally, unless I've missed something.
I think the Guardian's evidence was very much following the tenor of what I think I'm submitting, which is that if it cannot be said that she can remain where she is, brackets under whichever legal framework, is what I would say.
Well, let's look. Can we look? Would you bear with me and just look at the Guardian's report? So, child impact analysis on page B22, internal 5, and then she sets out in the way that's common for post BS in boxes. Paragraph 14. Balance of long-term fostering with Mr. and Mrs. D. And then paragraph 15 on B24, internal 7, placing L with adoptive carers. And there isn't an analysis in the report of the pros and benefits and detriments of placing her with long-term foster carers elsewhere.
It was certainly dealt with in her evidence, so in her oral evidence, and the court will have a note of that. Section A, just find that for you.
Just find the passage in the summary of Guardian's evidence.
Right. So this is towards the end.
It starts at page A90, the Guardian's evidence. Is that right?
Yes.
So can you help us?
Yes, I'm just looking to see if I can find a specific reference.
So I'm looking for is an analysis of the advantages and disadvantages of placement in a long-term foster care with other carers. So we're going to find that, are we?
Well, I'm just looking to see if I can find a specific reference, but you can see in the judgment that the judge refers to the Guardian's evidence about the lack reviews, the corporate parenting, decisions being made by other people. So those are the disadvantages. I'm not sure that there's any analysis of the advantages of long-term.
What I'm looking for is we don't have a transcript, and you said it's in the evidence. So where in the note of evidence, the judge setting or the Guardian setting out the advantages and disadvantages of. I don't know whether Miss Brooks is going to be able to prompt you if it's there.
My lord, it may be that if I address you on any other matters, and then highlight any specific paragraphs subsequently.
Okay. I mean, on paper, Ms. Manassi, it looks as though the Guardian's analysis of the long-term of the realistic options was in line with what Ms. Fairclough and Ms. Davis say, not what you say.
Well, I think the semantic difference is that it's what the mother and father and what their case was in terms of what they were proposing that the court does, and the local authority says it is not open to the court to make that decision. So that, I say, is the difference between us. I think I have made clear that, of course, the local authority has not discounted, and I think it's not been suggested that the local authority has discounted the possibility that that would be the long-term placement. It simply said it was not able to guarantee it. And therefore, any decision would have to be on the basis of weighing up the options without it being limited to long-term foster care with the Ds.
Can we look at? Well, you come back. You can come back later if you find something on this. But where can we look at the social work evidence about the options?
Yes.
So this is later on in our bundle. So she's got at 51. Adoption, SGO in favour of Mr. and Mrs. G, long-term foster care, return to mother with supervision order. Is that right? So I'm at B51, 52.
Yes.
Okay, so she's got 4 options. Okay.
Yes, because of course the SGO option, had these changed their mind about putting themselves forward, that would have been a realistic placement option that was properly open to the court.
Does there's no specific reference in this analysis to the Ds as long-term foster carers.
On paper, that's correct, yes. Again, she was asked significantly in her evidence about the care that they provided, issues to do with the harm moving L from that placement, whether to a different long-term foster placement or an adoptive placement, the risk of breakdown, the harm in the delay. So it cannot be said that the evidence was not fully explored in terms of those issues.
Okay. Well, was there a separate statement in support of the placement application?
No, I don't think so.
This was the only evidence from your local authority, was it?
I'm just checking to see the date of it to check if that was the last statement. I say that because, of course, the local authorities plan changed, as the court is aware. Yes, I think that's the February statement. Yes, I think that's the last statement.
Where do I find an analysis of the 2002 Act welfare checklist in the local authority's evidence? So you know what I'm saying. In this report, there is an analysis using the Children Act welfare checklist. But where do I find an analysis setting out the different checklist and to be applied in adoption decisions?
Yeah, there would have been a bundle, but I don't think we have the bundle with us.
Well, I prefaced that by saying, was there a statement in support?
I'm not. I have to admit, I don't recall there being a separate statement in support. There would have been a separate placement bundle. It would have contained the statement of facts, the Annex B.
Yes, but so just obviously there are, as you know, when an adoption decision is taken, including placement order, the court applies the different statutory welfare checklist with the important additional factors in section 1, subsection 4. As I read, the Guardian considers it in her report, but I couldn't see it in the local authority report. The local authority statement deals with the Children Act checklist, not the Guardian's check, not the Adoption.
Not the Adoption and Children Act.
So where do I find the local authority in its analysis of the options, considering the additional factors in subsection 4 of the section 1. So specifically, the likely effect on the child of ceasing to be a member of her family and becoming an adopted person, and the relationship she has with relatives and others, which would include Mr. and Mrs. D.
Again,
And the likelihood of that continuing, the value of it continuing, the ability and willingness of the Ds to consider, to provide the child with a secure environment, etc., the wishes and feelings of relevant people, parents and the Ds. All that should be part of the analysis which the local authority puts before the court, and I can't see it at the moment.
to be fair, there was quite extensive oral evidence on all of those issues. Those issues were fully aired in evidence, and the local authority was challenged extensively, as was the Guardian, in respect of those issues. But I think the court is correct that there is.
It's an omission from the written analysis.
Yes.
There isn't the crucial analysis of the permanency issues.
Yes, however, it is right that all of those matters were extensively dealt with in oral evidence.
And you say sufficiently covered in the judgment, do you?
Certainly the judge would have had those matters at the forefront of her mind,
Where do we find?
having driven a lot of that evidence.
But Ms. Manassi, you know what BS says. BS says, and it's the interest of everybody, particularly the child, for there to be a clear evidence to the local authority and the Guardian analysing the pros and cons of all the options by reference to the relevant checklist, and a clearly reasoned judgment setting out those factors. And is it your case that this judgment meets that test?
Well, I would say that the judge does set out what she says about the loss of the family members, what is bearing in mind the long-standing relationships, bearing in mind the risk of separation and the harm that is set out.
Yeah. What paragraphs do you rely on in particular?
She refers to the checklist, doesn't she, at paragraph 30?
Yeah,
The adoption checklist as well as the family checklist.
she does.
Paragraph 5, I suppose, deals arguably with
Paragraphs 117 onwards.
Okay. Yeah.
And I would say all of this was extensively aired in evidence.
Okay, so you said whatever the omissions there were from the written documents were rectified by your oral evidence, your client, in social work oral evidence.
Indeed.
Okay. What about the consent? Parents' consent?
Again, I would say if the welfare matters are fully aired, which in my submission they are, it is open to the judge not to have to repeat those considerations again in respect of the dispensing of the consent of the parents, should it be in the child's welfare interests. Can I assist you any further?
Have you got the email from the D social worker?
I've got the telephone number for.
Yeah. Have you got the email? Have you got the email of the 17th of June?
I do not. I can ask for that. I will do that.
Is that what you want?
I will do that.
Thank you very much.
Thank you.
Anything else you want to ask? Anything you want to
No.
ask, Ms. Mercy? Thank you very much. Ms. Brooks.
Good afternoon. Can I make it clear at this point, if your lordships didn't know already, that I wasn't at the hearing below. I will try my best to assist with any information that
Thank you.
your lordships want.
Thank you.
But I will at that point turn to my colleagues for assistance. The Guardian does not support the appeal, and your lordships will have seen the Guardian's skeleton argument for this hearing. it's important to realise that the Guardian's position as it was in her final analysis that Your Lordship referred to a moment ago was her position as it was at the date of that document, which was in December. So some months before the date of the hearing. And it was quite clear in that document that the Guardian was, even then, metaphorically tearing her hair out a bit because she recognised as well the value of this placement to this child and was frustrated that there wasn't a way through. And I think Your Lordship will...
And is she still tearing her hair out?
Well, I think she's tearing her hair out that we're in this situation and that information or understanding about the processes, the Guardian in particular has referenced in her evidence, her frustration that the foster carers weren't cognizant or understanding of the fact that it wasn't possible to simply say, look, this is what I want, and I want this forever, and I don't have to keep coming back every year or 2 years to show you all my figures again. That's not realistic, and that's just a process that they have to go through. And it doesn't matter how many times they say, but we don't want to do that, that's just the way it is. And it was that which frustrated the Guardian a lot. Your Lordship asked earlier on what were the options which the court was considering or did consider. Whatever anybody may have said in their shopping list of preferred options to the judge, it's clear that she had in mind consideration of the option of a placement with the current foster carers as long-term carers, because she considers that in paragraphs 15 is where she starts. There are a number of paragraphs. They're not all immediately sequential, but that's where it starts. And it's where I say, my lord, she rules out any kind of placement, really, with the current carers as being not realistic.
She
rules them out as being unrealistic.
So she rules it out as a realistic option.
That's right. So paragraph 15.
Hang on just a minute. So, the judge ruled out the D's as a realistic option, and you rely on paragraph 15.
So paragraph 15 is where the judge starts talking about the frustrations in the case, about the option for this child to stay with these carers. Where the judge says at paragraph 15, I don't have any guarantee in any shape or form that this little girl could stay with her current carers. She talks about how great they are and how happy the child is. Fast forward to paragraph 21.
15, 21.
Sorry, when I say 20, it should be 22, paragraph 22. The reason paragraph 21 is in there, I digress slightly, is because one of the points that the current carers make is, look, these are her needs now. This is why we have to curtail our work and why we require and can't go beyond or below the level of remuneration that we currently receive, is because she has a high level of needs. And the local authority's position has been, well, she does, but she's 3.5, and her high level of needs may not be at the same level when she's 10, 11, 12, which is why, of course, there's a process of reviewing the financial package. So the judge starts by talking about that. That explains why the judge is talking about self-medication in that paragraph there. Paragraph 22, she talks about, again, foster carers coped really well, but that they have not been able to reach any form of agreement on anything, whether special guardians or as long-term foster carers.
At this stage?
I can see they haven't been able to raise any...
at this stage?
I'll continue.
At this stage?
They are approved as long-term carers but not matched. Paragraph 23, the judge talks again there about wishing to... the carers wishing to adopt the child, but not even on the road. And unless there's some thinking outside the box, that is likely to falter on the needs to have sufficient funds to meet the needs of the child and the rest of the family in light of the restrictions on their earning capacity. And the judge then considers it again at paragraph 25.
Well, 24 is, you can't just ignore what she says. She's going through it.
Yes, 24, your lordship's quite right. And she acknowledges that the positives for this child of remaining with these carers are, my words, not the judge's words, high in many respects. And then, of course, the
25. Do you? I suppose you attach. Looking, this is very helpful, Miss Brooks. The last 5 words of paragraph 25.
Yeah. So the judge is in effect saying, look, all the evidence is that this young girl is thriving in the care. There are issues, and I won't expand on those at the moment, other than to say the judge recognised that there were other issues. It wasn't just about finances, but even just dealing with finances a moment, what the carers are asking for is simply not realistic, because they're not just saying we need our financial support package to be the equivalent of what we have now, whatever we decide to do. That's not the primary issue. The primary issue is this wish to just have this unchanged, unreviewed for 14 and a half years. Of course, the problem with that is it doesn't reflect the reality of any family's situation on the ground. Things change for good or bad, which is why there needs to be that process of review.
But is that the same thing as saying that that's not a realistic option to be considered? Because it's one thing to say the parents, what's being suggested here is not realistic because of the need for a guarantee which can't be given. But is that exactly the same thing as saying that the long-term fostering option is not realistic?
I think that is the same thing, for the same reason. How can a potential placement be realistic when that placement will rely on regular reviews, will rely on the local authority, a head of service, let's say, agreeing in 2 years' time, 3 years' time. Hang on a minute, we've got this family who are receiving possibly double, almost double what foster carers in-house are receiving. This can't be justified.
I agree. If one assumes that the positions of the two parties don't change at all, one can equate the two, but is it necessarily the right approach to this decision to assume, let's say, that the position of the Ds will not change, because we know that to some degree or in some way it has?
Well, the position of the Ds to some degree has shifted in that they are prepared or more open to the idea of adopting. But I agree with what my learned friend for the local authority said. We don't actually know to what extent that's changed. And the Guardian, of course, can't forget that in July of last year, the carers put themselves forward, or were assessed. So it was earlier than that. The carers were assessed to care for this child. And here we are almost a year later, and still really no clearer about whether this barrier, and it was a barrier, which is the immutable nature of the package that they sought, whether that's changed.
I mean, it is quite striking. I don't recall a case in which, certainly before this court, which I've sat, in which the parties can't agree about what the realistic options were before the judge. You've been very helpful, Ms. Brooks, and maybe you've got some more phrases you're going to alight on. You've only got to paragraph 25. My sense was that that it wasn't. The judge wasn't saying it was a realistic option.
No, I
for the
agree.
postman
She
duties.
wasn't.
But it doesn't leap off the page. And Miss Fairclough and Miss Davis, who were there, disagree.
So
I mean, whether
if the judgment had been, I'll choose my words carefully, more fully set out and more
or complied with BS,
formally set
complied with the BS. This is exactly what Lord Mr. James Mumby was all about. Isn't it? I mean, this is the whole point. We haven't got BS. I have to go look at it over remind myself over the German. But we've got to see that without the clarity of structure, you can't even say what the judge thought the realistic options were, let alone what the pluses and minuses of each were.
But looking at the judgment as a whole and taking into account those paragraphs that I've just mentioned, so if the judge were to say very formally, these are the options I'm considering, and I'm considering X, Y, Z, it appears from the judgment that she has said, well, of course, placement with the Ds is not really an option, is it? So that's not one of my options to consider. That's not a realistic option. So that's not going into the re-B analysis.
Is long-term foster care with the Ds now a realistic option?
I don't know, my lady, whether it is a realistic option. I misspoke. There is nothing that I've seen or read that would suggest that that is now a long-term option. What's been referenced is a willingness to talk about adoption and to put themselves forward, or to consider putting themselves forward for adoption.
That's what the 17th of June email says, does it?
Apologies, I don't want to jump up unnecessarily, but that email has now come through, and
Right.
it is perhaps Ms. Brooks would like to read that before continuing.
Well, I better had, hadn't I?
I just don't want to.
Can yeah,
send it
we
to
like it. Could you forward it electronically somehow to whoever you're somebody
I
within the
sent it to
office?
Ms. Chauhan, whose email address I had earlier. Whom should I send it instead if that's not yet through?
Ms. Shahar, Sonia Shahar. Yes,
Yes.
she's the lawyer, the family lawyer.
I've sent it to her.
Thank you very much. Can you send it to Gareth Williams? You've got Gareth Williams, who's my acting clerk as well. Got his email address? GarethWilliams1@justice.gov.uk. Anyway, do you want to read it out, Miss Brooks?
Yes, well, why don't I do that? It might be quicker.
don't
I
you?
don't mind. 17th of June, then. So this is from somebody at All For You Fostering. All For You Fostering, of course, is the fostering agency.
Okay, so this is the social worker employed within the agency.
That's right. So this is their supervising social worker.
Sure.
And dated 17th of June. Hello, Peter. I think that's reference to the allocated social worker. I've had numerous conversations.
Just so I know, is it going to be is it a long email?
No, I can go through this in about a minute.
Okay, right.
I've had numerous conversations with Mr. and Mrs. D following last week's PPM, so permanency planning meeting. The reality of the child potentially moving to another family has made them reflect.
Just a moment. Right, by the way.
Has made them reflect and reassess their position. First and foremost,
Hang on.
they're worried that a move from their family
Just a moment. First and foremost, they're worried. That a move, yes?
will cause her disruption, upset, and loss. They have made it clear that they wish to continue to care for her and find the thought of her leaving their family upsetting. They want to do all in their power to provide her permanence. Since the child's care plan changed to adoption, the carers voiced that they wanted to adopt her, but were hesitant to pursue adoption under an arrangement where allowances were means tested and reviewed annually, as this did not provide family financial security.
Means tested and reviewed annually.
Yeah. So they were hesitant to do that, where those were the...
Reviewed annually, sorry, just say that again, after annually, because...
As this did not provide family financial security.
Yeah.
A full financial assessment...
Sorry, a full...
Full.
Yes.
Financial assessment that would help the carers know what an adoption allowance would look like has not been completed. I understand the financial assessment forms were sent to them in February 2022, following a placement planning meeting and ahead of a court hearing. The carers were asked to submit this in a short time frame. They were unable to collate the required documents in the required time, so the assessment was not completed. They asked for an estimate of what their allowance would look like in terms of their income. But were told it was not possible to provide this. The carers understand that any adoption allowance would be means tested and reviewed annually. The reality of the child having to move has made them reflect that they do not want this to prevent them continuing to care for the child long term.
Sorry, but or that? Read that last sentence again, would you? From the reality of the child
local authority having to move them has made them reflect that they do not want this to prevent them continuing to care for the child long term. Right. They want to let the local authority know that they want to be considered as prospective adopters. They understand that any adoption allowance would be lower than the fostering allowance they have been receiving and means tested annually. And I'm going to read the last paragraph out because
I'm not quite as fast as you think I am. Any fostering allowance would be lower
than the fostering allowance.
Any adoption allowance, any fostering allowance
they have been receiving and means tested annually.
Thank you.
And then I thought, my lord, if I read the last paragraph out, and then your lordship could just take a general note of what that says. Unquestionably, this is coming from their social worker, unquestionably it will be in the child's best interests to be adopted by the Ds, and we hope the local authority will thoroughly explore them as potential adopters. It seems their reluctance to enter a financial arrangement that was means tested and reviewed annually is what has prevented the matter being pursued. Now they are willing to proceed, knowing any allowance will be annually reviewed. So I think that's clearly more information than we had before.
Much more information, yes. Thank you.
And obviously that's in respect of adoption. What we don't know is what their position would be in terms of fostering. I can almost feel the Guardian pulling a hair out on the other side of the screen, reflecting the frustration really that she felt during the proceedings.
Well, has the Guardian seen that before you read it out?
No.
I think I'm going to I think what I'd like to do now is rise for a few minutes just to have a word with my lady and my lord, and then come back before 1 o'clock. And it may well be that there are specific things we want you all to do in the light of that, but maybe there aren't, in which case we'll let you know. But we'll just rise at the moment just to have a brief chat.
Still recording. Yeah.
So
Yeah, because it's not going to be very long, is it? I think the issue is this: the local authority are not saying no to the The issue is whether the why I might say. Anyway, it's I was in the RMT, I wouldn't work anymore in this condition. Yeah, it's freezing. See, it's actually quite sexist because I think you'll find that you're okay and they're probably okay, but all the women in the room are freezing.
In summer really hot.
Yeah.
Crime gets really hot.
You're freezing.
Or in winter crime's really cold and then sometimes they have heaters underneath.
Mm. Mm. It wasn't it? Mm.
Right. Well, we've no specific request, but we'd like you all, please, to consider this email further in the light of what of its contents. In particular, we'd like the Guardian's instructions, please, Miss Brooks, as to where she takes this forward. Mr. and Mrs. D are not parties to these proceedings. Obviously, they can't be parties. As the lady and I and another judge said in another case not so long ago, we are P. But nonetheless, obviously, it's extremely helpful to have this email. What we don't know, trying to look at the picture as a whole, is what Mr. and Mrs. D would now be saying about long-term foster care, which was actually where a lot of the focus this morning's attention has been. So, and of course, you've not been dealing with them direct. Your social workers haven't been dealing with them direct, but they've been dealing with their social worker direct.
We do have their telephone number, so
Okay.
we are able to contact them today. Another social worker also was speaking with them yesterday because he sent them the live link to today's hearing and invited them. And
all right. Well, what we would like to know is whether if the plan was not adoption but long-term foster care, what would Mr. and Mrs. D's position now be with regard to that? In other words, would they be willing to continue to look after Elle as long-term foster carers if the plan was a care order rather than adoption? Is that clear, Ms. Manassa?
yes,
So sorry to interject.
Oh,
but
yeah.
I think it might be worth just clarifying whether that would be there would be any
Oh yes,
conditions attached to
absolutely,
that.
exactly. Would it be? In other words,
Same flexibility.
would the flexibility which is reflected in the email which has been read out, would the same flexibility be shown with if it was long-term foster care?
we can
And that's, may I say, that is just an inquiry from the court.
yes.
No pressure at all on Mr. and Mrs. D or anybody else. We just like to know so we get the full picture.
Of course.
Okay. One other matter I'd like you all to consider is if, and I stress it's if we were to allow this appeal, and the matter would go back for rehearing, whether that should be back to the same judge or to another judge. I'd like your views on that. But I stress, Ms. Manassa, that doesn't indicate we've made our minds up one way or the other.
No.
Anything else you want to ask? All right. Okay, thank you very much. All right, well, we'll look forward to seeing you at 2:00.